Good day, class. This is Attorney Season. Welcome to Criminal Law Book 1. Today I'll be discussing reading material number 9. So let's start and please listen and take the notes. So, mitigating circumstances. What are mitigating circumstances? So, mitigating circumstances are those circumstances, okay, which, if present or attendant in the commission of a felony, would reduce the imposable penalty because it shows lesser perversity or criminality of the offender. So again, mitigating circumstances are those circumstances like incomplete self-defense, okay? Like minority, uh, a child above 15 years old in one day but below 18 and he acted with discernment. So that's a privilege mitigating circumstances. Senility or seniority or a person above 70 years old. Praeter intentionem, okay? Immediate vindication of a grave offense. That there's sufficient provocation or threat on the part of the offended party, or there's passion or obfuscation, or the offender voluntarily surrendered himself to a person in authority, or he voluntarily confessed his guilt in open court, okay, or other illnesses of the offender as would diminish the exercise of his willpower, such as when the said offender is suffering from kleptomania, or the offender is a kleptomania, or when the offender has a physical defect or other analogous circumstances. So those circumstances, that I mentioned are considered mitigating circumstances, and if present, okay, in the commission of the felony, would reduce the imposable penalty. Let's just say a minor or a child above 15 years old but below 18 years old and acted with discernment committed the crime of robbery. Okay? And since he is a child, a minor, he can invoke the privilege mitigating circumstance of minority. And such minority is a privilege mitigating circumstance which will reduce the imposable penalty by 1 or 2 degrees. Okay, so if such child who committed the felony of robbery, felony again, acts or omissions punishable by the revised penal code, okay, and if he committed such felony, it will reduce the imposable penalty. So let's just say, for example, lang, the imposable penalty for robbery is repression temporal, and then he will invoke minority as a defense. Okay, like he is 15 years old in one day but below 18, and that uh, he acted with discernment. So it will be a privilege mitigating circumstance. So ang lower siya 1 to 2 degrees. So unsa may lower sa reclusion temporal? So prison mayor or prison correctional. So nga na. Okay? And mitigating circumstances need not be alleged in the information. So pwede ra dili siya i-allege sa information, okay, of the prosecutor in order to be appreciated. Provided that such circumstances, like there's prior intention, voluntary surrender, voluntary plea of guilt, minority, seniority, incomplete justifying circumstances, dapat it must be shown and proven during the trial. Okay, again, need not be alleged in the information provided such circumstances is shown and proven during trial. Okay? So, kinds of mitigating circumstance. So, there are two kinds. Number one, the ordinary mitigating circumstance, and second, the privileged mitigating circumstance. So, what's an ordinary mitigating circumstance? So, an ordinary mitigating circumstance is one which may be offset by a generic aggravating circumstance. And if an ordinary mitigating circumstance is not offset by a generic aggravating circumstance or EC, it would reduce the imposable penalty to its minimum period. So let's just say the offender invoked praeter intentionem, that he had no intention to kill the victim. Okay, however, by as a consequence of his actions, like iyang gisumbag ang victim or iyang although ang victim namatay, so there's notable disparity. So it's an ordinary mitigating circumstance. So pwede siya maka-invoke og ordinary mitigating circumstance. Let's just say namatay. An example sa imposable penalty is reclusion temporal in its medium period. And there's an ordinary mitigating circumstance of praeter intentionem. So, and wala po'y aggravating circumstance. So, ang imposable penalty is reclusion temporal in its minimum period na. Why? Because there's an ordinary mitigating circumstance and there's no aggravating circumstance. Okay? So what if na ay usa ka mitigating like praeter intentionem and one aggravating circumstance like nighttime. So what will happen? So if there's one ordinary mitigating and one generic aggravating circumstance, uh, si generic aggravating circumstance, iyang i-offset si ordinary mitigating circumstance. So instead nga automatic ma-minimum imposable penalty like reclusion temporal, medium, automatic ma-minimum pag na-ordinary mitigating circumstance. However, na may generic aggravating circumstance, therefore, yang i-cancel ang ordinary mitigating circumstance as if wala ordinary mitigating circumstance. So, if na ay generic aggravating circumstance, as is ra nga medium period. Dili na mo reduce. Why? Kaya gi-offset man siya sa generic aggravating circumstance. Okay? Ang praeter intentionem na ordinary mitigating circumstance. Again, ang ordinary mitigating circumstance kay pwede siya ma-offset by a generic aggravating circumstance. So if na ay aggravating circumstance, dili ma-lower, okay? Dili ma-lower ang imposable penalty to its minimum period. How about privilege mitigating circumstance? So privilege mitigating circumstance is one which cannot be offset by any AC or aggravating circumstance. So dili siya pwede ma-cancel. So let's just say for example, a minor 15 years old in one day but below 18 and acted with discernment, committed robbery at night, okay, or during nighttime, and nighttime is an aggravating circumstance. And since privilege mitigating circumstance man, so dili ma-cancel ni nighttime ang minority nga privilege mitigating circumstance. Therefore, mo-reduce ra gyapon ang imposable penalty. So let's just say ang imposable penalty sa robbery, reclusion temporal and medium period, mo-lower gyapon siya by 1 or 2 degrees. So either prison mayor to prison correctional. Okay, even if na ay aggravating circumstance. Kay nga naman, it is a well-settled rule that a privilege mitigating circumstance is one which cannot be offset. Dili siya pwede makancel. Okay? And the effect of privilege mitigating circumstance is to reduce the imposable penalty. I-reduce yun niya. Not only to its period meaning minimum, medium, maximum periods, but by 1 or more degrees. Okay? It's like, ang degrees meaning reclusion perpetua, then may mo siyang reclusion temporal, prison mayor, prison correctional, arresto mayor, arresto minor. Na yung mga degrees. Okay? So, Article 13 talks about mitigating circumstances. So, the following are mitigating circumstances. So, number 1, incomplete justifying or exempting circumstance. So, those mentioned in the preceding chapter, like the justifying circumstances and exempting circumstances, when all the requisites necessary to justify or to exempt from criminal liability in the respective cases are not attendant. Okay, so let's just say in self-defense, okay, Di ba naman ay tulo ka elements? Okay, in order for a person to invoke self-defense. Number one, unlawful aggression. Second, reasonable necessity. That means employed to prevent or repel such aggression. And lastly, lack of sufficient provocation on the part of the person defending himself. So if lacking siya sa third element, or let's just say second element, okay, mahimo siyang incomplete justifying circumstances. And pwede si accused mo invoke og mitigating circumstance para ma-lower iyang imposable penalty. So incomplete self-defense. So in case of incomplete self-defense, incomplete defense of a relative, incomplete defense of a stranger, there must always be unlawful aggression in order for the mitigating circumstance to mitigate. Dapat dili mawala ang unlawful aggression. The first element is very important. Okay? So, dapat na ang unlawful aggression. Bahalag mawala si second element, katong reasonable necessity, that means employed to prevent or repel such aggression. Or third element, or the last element, the lack of sufficient provocation on the part of the person defending himself. Okay na nga sila, wala kay pwede si accused na invoke og incomplete self-defense. However, dapat dili mawala si first element, si unlawful aggression. Ano yung importante? So, let's follow this rule. It is only ordinary mitigating if only the element of unlawful aggression is present. So let's just say absent si second and third element and naa si unlawful aggression nga first element present. So may mo siyang ordinary mitigating lang. Okay? But however, it is privileged mitigating if aside from unlawful aggression na ay usa pa ka element nga na majority of the elements are present, like two. Okay? Either reasonable necessity or lack of sufficient provocation. Okay? So if dua ka elements ang present, aside sa unlawful aggression, maybe na kay lack of sufficient provocation on the part of the person defending himself, i-treat na siya, kanang incomplete self-defense, i-treat na siya as privilege mitigating circumstance. And it could lower the penalty by 1 to 2 degrees. Okay? Unlike in ordinary mitigating nga, if naa, and walay aggravating circumstance, mahimo lang minimum, okay, period, imposable penalty. Minority or seniority. The offender is under 18 years of age. So this refers to a child nga age of 15 years and 1 day to but below 18 years old. Kaya nga naman, if 15 years old below, di ba, exempting circumstance mo na. So dapat 15 years old and 1 day, but below 18 years old, mo na siya pertainan. And provided nga nag-act of discernment. Discernment meaning the ability to know what is right or wrong. Okay? And or over 70 years old. Katong nagulang. So in the case of the minor, he shall be proceeded against in accordance with the provisions of Article 80. Okay? There are two mitigating circumstances here. Number one is minority and second is seniority. So minority, remember that if minority is not exempting, let's just say 15 years old below, okay, muna exempting circumstances. And if ever 15 years old and 1 day to 18, but below 18 years old, but acted with discernment, so dili na siya exempting, it is always and always a privilege mitigating circumstance, never an ordinary mitigating circumstance. Okay, so lower by 1 to 2 degrees. So if the offender is over 15 but below 18 and he acted with discernment, meaning the ability to know what is right or wrong, it is not exempting but a privilege mitigating. Seniority, person over the age of 70, is generally ordinary mitigating circumstance. Third, the offender had no intention to commit so grave a wrong as that committed. So this pertains to praeter intentionem. So elements, the offender committed a felony, a felonious act. And there must be a notable or notorious disparity between the means employed by the offender and the result of the felony. So example, A and B were fighting. A boxed B, B boxed A. A retaliated and boxed B again. When A boxed B, B's head hit a cemented wall, and so he suffered cerebral hemorrhage and thereafter causes death. So is A criminally liable for the death of B? Of course, definitely yes. Okay, because when A boxed B, he was committing a felonious act. Therefore, he is criminally liable for the resulting felony, although it be different from which he intended. But can he be given the benefit of brighter intentionem, that he has no intention to commit so grave a wrong as that committed? The answer is yes. Why? Because there was a notable disparity between the means employed by the offender in the resulting felony. Who could have anticipated that by the mere act of boxing, that would result? Who would have thought, diba? Okay, so therefore, he should be given the benefit of brighter intentionem. Another example from the book of Reyes, the husband who was quarreling with his wife punched her in the abdomen. Si husband hindi punch ang wife's abdomen, causing the rupture of her spleen, from which she died. So, muna siya another example of brighter intention. So, there was notable disparity, okay, sa act sa offender nga pag-punch abdomen din would have anticipated nga ma-rupture ang spleen, etc. from the act of punching, di ba? So, mitigating. Sufficient provocation or threat. So, that sufficient provocation or threat on the part of the offended party or the victim immediately preceded the act. So, there's sufficient provocation or threat. So, the following are the elements of sufficient provocation. The provocation must be sufficient, okay? And then it must be immediate to the commission of the crime, and it must originate from the offended party, okay, the victim. So provocation is any unjust or immoral act or conduct on the part of the offended party which is capable of inciting, exciting, or inflating another. When is provocation sufficient? So there must be two elements for provocation to be sufficient. Number one, it must be adequate to steer a person to commit a wrongful act, and it must be proportionate to the gravity of the crime. So, immediacy or immediate. So, the second element requires that the provocation must be immediate to the provocation of the crime. There must be no lapse of time between the provocation and the commission of the crime. Okay? So, examples. So, when the deceased abused and ill-treated the accused, okay, by kicking and cursing the latter, the accused who killed him committed the crime with this aggravating circumstance. Okay, very important. Immediate vindication, sufficient provocation or threat. Okay, so again, when the deceased abused and ill-treated the accused, okay, si deceased katong na victim iyang patiran, gi-curse, accused, ang akusado. Okay? So, of course, naglagot si accused. So, gipatay siya. So, even though gipatay, okay, criminally liable si accused, maka-invoke siya mitigating circumstances. Okay? Another example, when in his house, the accused saw an unknown person jump out of the window. Okay, so nangabit yung asawa di ani. And his wife begged for his pardon on her knees. He killed her tungod sa kalagot niya. Okay, yung gipatay yung wife. Eh, klaro kaya nag-sex kuno ay sa room, etc. Kita gud siya tawo nga ni-jump sa window. So such conduct on the part of his wife constitutes what? Sufficient provocation to the accused. That's People versus Marquez. So mitigating. And lastly, the deceased, while intoxicated, hubog si deceased, ano yan, found the accused lying without having prepared the evening meal. This angered the deceased, and he abused the accused by kicking and cursing him. Okay? So, a struggle followed, and the accused stabbed him with a penknife. Very good. And then the accused was entitled to the mitigating circumstance that sufficient provocation or threat immediately preceded the act, therefore mitigating. Next is immediate vindication of a grave offense. So that the act was committed in the immediate vindication of a grave offense to the one committing the felony, his spouse, descendants, or relatives by affinity within the same degrees. Uh, what are examples of immediate vindication of a grave offense? So in People versus Ponggol, or being accused by the victim, si victim, yung gi-accuse siya, that the accused stole the former's rooster. I-accuse niya, what? Wag mo na. Which made the latter, which made the accused feel deeply embarrassed na ulawan siya, kaya pasingilan siya nawat. And the encounter took place in about half an hour's time. Okay, so immediate vindication of a grave offense. Okay, so mitigating. Doniego versus People, or People versus Doniego, stabbing to death the son of the accused, which most naturally and logically must have enraged and obfuscated him. That seized by the feeling of hatred and rancor, he stabbed indiscriminately the people around. Okay? So that's immediate vindication of a grave offense, which is a mitigating circumstance. Grabe rapod. Okay? People versus Duniega. A 1963 case. Passion or obfuscation, that having acted upon an impulse so powerful as naturally to have produced passion or obfuscation. Okay, let's not dwell on the elements, but on the examples. So, one good example is the accused is entitled to the mitigating circumstances of passion or obfuscation, where he hit the deceased, okay, the victim ba? Upon seeing the deceased or the victim box his 4 years old son, gisumbag ang iyang 4 years old son. So the actuation of the accused arose from a natural instinct that impels a father to rush to the rescue of a beleaguered son, regardless of whether the latter be right or wrong. So that's People versus Castro. So mitigating, involve siya mitigating circumstance of passion or suspicion. Second example, that the act of the deceased in creating trouble during the wake of the departed father of defendant appellant scandalizes the mourners and offends the sensibilities of the grieving family, considering that the trouble created by the deceased, okay, deceased or katong victim, was both unlawful and sufficient to infuriate the accused. So his guilt is mitigated, okay, by invoking passion or obfuscation. So, same example lang ne. So, number seven is about voluntary surrender and voluntary plea of guilt. So, number seven, the offender had voluntarily surrendered himself to a person in authority. Let's just say si Mr. A, yang gipatay si Mr. B. So, after sa iyang pagpatay, ni-diri siya din sa police station, kaya mo surrender. Okay? Or that he had voluntarily confessed his guilt before the court prior to the presentation of evidence. So during arraignment, ni plea of guilt dayon si si accused. Guilty, Your Honor. Okay, upon reading of the information, yun siya, guilty, Your Honor. Okay, so that's voluntary plea of guilt. Okay, so there are two mitigating circumstances here. Number one, voluntary surrender, and second, voluntary plea of guilt. So if both are present, if both present, voluntary surrender, then voluntary plea of guilt, like si accused after killing another person, may voluntary surrender, and in open court, may confess siya, na guilty siya sa commission of crime, may confess siya. So, makonsider siya as two mitigating circumstance. Okay? So, what's voluntary surrender? So, elements of voluntary surrender. The offender had not actually arrested. Wala siya gi-arresto. Okay? Offender had voluntarily surrendered himself. it to the police, and such surrender must be voluntary. So it is necessary that the offender has not yet been arrested. It is necessary that he surrender to a person in authority. The surrender must be voluntary. Okay. Voluntary plea of guilt. The guilt tendered is confessed spontaneously and without conditions. And he confesses guilt in open court, preferably during arraignment. And the confession that was made was before the presentation of the evidence for the prosecution. Physical defect. So that the offender is deaf and dumb, blind, or otherwise suffering some physical defect, which thus restricts his means of action, defense, or communication with his fellow beings. So for this mitigating circumstance to lie in favor of the accused, it is necessary that there must be a connection, a relation between the physical defect and the crime committed. Okay? So it is necessary that the said physical defect must have restricted his use of action, defense, or communication with his fellow being. So this is a good example. A blind beggar. Okay? One time, he was begging for alms. Suddenly, he was injured on his head with a wound. It was so strong that he fell on the ground, wounded. Angry, he stood up, took his cane, and retaliated by hitting the person next to him, not knowing that it was not a person, uh, but an innocent passerby. The innocent passerby suffered less serious physical injuries, so the blind beggar was prosecuted for less serious physical injuries. So, question: is the mitigating circumstance of physical defect present so as to reduce the imposable penalty? The answer is yes. His being blind restricted his means of action, defense, or communication with his fellow being. His intention was to hit the person who injured him with a wound, but because of he could not see, he hit an innocent passerby. So there was a relation between the physical defect and the crime committed. And therefore, it will mitigate his criminal liability. Number 9 talks about uh, illness of the offender, as would diminish the exercise of the willpower of the offender, without, however, depriving him of the consciousness of this act. So one good example is a person suffering from kleptomania or a kleptomania. Okay? So A is a kleptomania. He has this urge to steal. Now his urge is to steal diamonds. So one time he was in a party, he was talking to a lady with a diamond earrings, necklace, diamond watch. Then after conversation, the lady went to the restroom, and upon looking at the mirror, she shouted. She was shocked. The diamond earring, necklace, watch, and bracelet were all gone. It was already taken by the said accused. A was prosecuted for theft. Will his illness mitigate his criminal liability? The answer is yes, because it diminishes his exercise of his willpower without depriving him of consciousness. He knew that he was committing theft. Kapalo siya, namangawat siya. He knew that he was taking personal property, diamonds of another, but wala siya ka-control because he is suffering from kleptomania. And if you are suffering from kleptomania, you have this urge to steal. Okay, so he has a diminished self-control to prevent the commission of the crime. So it will mitigate or reduce the imposable penalty, but it will not exempt. Okay, such person. Analogous circumstance. So any other circumstances of a similar nature and analogous to those above mentioned. So, example, a public officer who has malversed public funds voluntarily return the public funds. So, it is similar to voluntary surrender. Kapag voluntary surrender niya public funds, it is similar or akin to voluntary surrender. It's an analogous circumstance. So, another example is when the defendant is 60 years old with failing eyesight. Okay? Similar na siya to a case of one over 70 years old. Therefore, mitigating, you can invoke seniority as a defense even if 60 years old siya. But naman siya failing eyesight. Or if a person is already 65 years old, okay, but sickly and suffering from a disease. Okay, and it is similar to seniority, so it will mitigate his criminal liability. Next is okay, the end. So thank you very much for listening. Have a great day.